Good day everyone, I'm Alex, moderator for this webinar. I welcome everyone for today's webinar, which is False Claims Act, cases involving millions in medical fraud, what you need to know about recent court decisions. I would now like to introduce our presenter for today, Mark R. Bringelman. Mark R. Bringelman is an experienced attorney in administrative and professional licensure law representing a wide variety of professional clients from licensed individual healthcare practitioners or to licensed healthcare facilities and many others. As frequent participant in continuing education, Mark has been a presenter for over 30 national and state organizations and private companies. I would now like to hand over the floor to the speaker. Over to you, Mark.
Thank you, Alex, from Conference Panel. This is Mark Bringelman. I'm an attorney in Frankfort, Kentucky. So we are broadcasting at this moment live from the Eastern Time Zone in the Commonwealth of Kentucky. I'm based out of our capital city of Frankfort, Kentucky. And so good morning to all of you on the West Coast and on Mountain Standard Time, and good afternoon to those of us here on Eastern or Central Time. So I'm going to go ahead and advance the slide. Thank you. Yes, as it was announced, I hold bachelor's and master's degrees from Emory University, my law degree from the University of Kentucky. I've done CE now for over 50 organizations. False Claims Act cases, we want to make sure that we have covered the basics of federal False Claims Act cases. We have a common set of expectations and go over the goals and the content of this program, what it does and doesn't cover. We're going to take just a 3 or 4 minute detour here about the basics of health laws as they apply to the healthcare practitioner individually. Morals is concerned with the principles of right and wrong behavior. Now it talks about the things that you do. So false claims involve claims and billings. We talk about ethics, morals, and the rule of law as explaining fundamental rights. Also, the law covers standards for due process, how false claims cases are made and handled, whether it's civil or criminal. Here's a quote by a U.S. Supreme Court Justice, Oliver Wendell Holmes. The law is the witness and external deposit of our moral life. It's the history of the moral development of the human race. There's another quote that I like to say to clients, quote, I don't want a lawyer to tell me what I cannot do. Just think about the integrity of the doctor-patient relationship, the power differential, the vulnerability of the patient. The doctor holds confidential information. Codes of ethics include those, let's say marriage and family therapy. They have a code of ethics that's about 11 years old now. It's not binding. So codes of ethics provide aspirational goals and voluntary standards and guidance. You will see how these voluntary standards or subjective things play out in False Claims Act cases. There are limited consequences for violating a code of ethics. It's meant to be guidance only. There is an importance of federal law for False Claims Act cases. They involve millions of dollars in medical waste, fraud, and abuse. So there's liability under the False Claims Act. More on the importance of federal law. The most recent statistics that I could come across go back to just right before the pandemic, 2019, that over 71% of all False Claims Act cases were initiated by whistleblowers. And individuals who or entities that knowingly file fraudulent or false claims that are payable by government healthcare program are subject under the False Claims Act to criminal and civil liability. Civil liability, the most frequently kinds of fact patterns found to violate the law. Upcoding, we'll define that in a moment. What has happened with Obamacare or the Affordable Care Act? So this is the U.S. Supreme Court case that changed everything. This crazy statute, I call it crazy because it was the latter, I believe it was the latter of 6 years, or you had 6 years to bring a lawsuit, the latter of either 6 years or 3 years from when the government discovered or reasonably should have discovered the facts, but in no event longer than 10 years. So the U.S. Supreme Court ruled that these statute of limitations applied equally regardless of whether the government intervened or not. The Hunt case means a relator can have up to 10 years to file the claim. You have to keep records of the patient 6 years from the last date of service. And so let's rip through some federal court cases. The Winter case from the Ninth Circuit in 2020, the top takeaway is that under Federal False Claims Act cases, a certificate of medical necessity authorizing inpatient admission was a false claim. Okay, the Benassi case re Trinity Health, case from just a couple years ago, the Eighth Circuit decided this in 2020. Top takeaway is that fraud claims must be pleaded with sufficient particularity. United States v. Druding, XRL Druding versus Care Alternatives, a Third Circuit case from 2020. Top takeaway, medical expert testimony that Medicare reimbursement could be false saved the claim. So let's wrap up here. For individual healthcare practitioners, what do you need to know to avoid liability and risk? If you're a healthcare facility, know your billing rules or hire someone who does. Your facility is liable for their billings. Have we covered it all? The basics of Federal False Claims Act, 2 types of prosecutions, millions of dollars at fraud and stake, the U.S. Supreme Court case that stretched out that statute of limitations to 10 years for everybody. We've updated a little bit on some other federal court cases, gave a bit of a detailed analysis, and we have given some basic tips and techniques to defend yourself from liability.
Thank you, Mark. And that does conclude the session for today.